You own a small business, a restaurant, a pharmacy, a boutique. It does not matter which. Until June 25th, 2026. If you did nothing at all, said nothing, posted nothing, the law in several states did the work of keeping armed customers out for you, automatically, by default. That default just flipped. If you have not actively decided what your policy on firearms is and posted or communicated that decision clearly, your silence now means something completely different than it did a few weeks ago. This is not a video about whether that change is good or bad. This is a practical playbook for business owners specifically, what actually changed, what your real options are, and how to actually implement whichever policy you choose without leaving yourself legally exposed or creating confusion for your staff and customers. Quick thing before we get into it. I cover legal changes that actually affect how you run a business, not just abstract constitutional theory. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into exactly what you need to know and do. Here is the ruling in the fewest words possible because you need the baseline before we get into your actual options. In Wolford versus Lopez, the Supreme Court struck down, 6-3, a Hawaii law that had presumed licensed concealed carry permit holders could not bring a firearm onto private property open to the public unless the owner affirmatively said otherwise, through a sign, spoken words, or something in writing. The court ruled that default violates the Second and 14th Amendments. The practical effect is that the presumption flips back to the traditional common law rule. A licensed carrier is presumed welcome on your property unless you specifically say otherwise. This ruling directly struck down Hawaii's law, and it sets the controlling legal standard for 4 other states, California, Maryland, New York, and New Jersey, that had adopted similar default consent laws, meaning if your business operates in any of those 5 places. This is not abstract, it is your actual operating environment right now. Let's be completely clear about what did not change, because this is the single most important thing for you to understand before doing anything else. You did not lose any authority over your own property. None. You can still ban firearms from your business entirely if that is the policy you want. A sign, a verbal notice to a customer, something posted at your entrance, any of these remain completely legal and completely enforceable. If a customer ignores a clear no firearms policy after being told, they are trespassing, exactly the same as before this ruling. What changed is only what happens if you say nothing at all. Silence used to mean no. Now silence means yes. That is the entire practical shift, and understanding that it is that narrow should immediately calm down anyone who assumed this ruling means they lost control of their own storefront. So here is your actual decision, laid out as 3 real options, because you genuinely have to pick one now, rather than defaulting into whichever one used to be automatic. Option 1. You decide you want to prohibit firearms on your property, the same policy you may have had automatically before this ruling, without realizing it was automatic. If that is your choice, you now have to actively communicate it, because the law no longer does that work for you. The most durable way to do this is a clearly posted sign at your entrance, visible before someone walks in, not buried somewhere inside. There is no single, nationally uniform legal requirement for exactly what that sign has to say. But the safest practice is unambiguous language. Firearms are not permitted on these premises, rather than something vague that could be argued about later, and consider posting in multiple languages if your customer base warrants it, since a sign a customer genuinely could not understand offers weaker legal footing than one that clearly communicated your policy. Train your staff on what to do if a customer is visibly armed despite the posted sign, a calm, direct verbal request to leave or secure the firearm, and a plan for what happens if they refuse, generally treating it as you would any other trespassing situation, calling law enforcement if necessary rather than staff attempting to physically enforce the policy themselves, since asking an employee to physically confront an armed customer creates a far more serious safety risk than the underlying policy violation itself. If you operate in multiple locations, confirm each location is separately and visibly posted, since a sign at one location does not extend any legal protection to another location without its own posting, a detail that trips up multi-location businesses that assume a single corporate policy statement is sufficient without location-specific signage actually being installed. Option 2, you decide you are comfortable with the new default, meaning you take no action at all and allow licensed carriers on your property under the restored presumption. If this is your choice, genuinely the simplest of the 3 options, you still have real responsibilities. Make sure your staff understands the actual legal landscape, specifically that they should not be independently telling customers firearms are banned if that is not actually your policy, since inconsistent messaging from different employees creates confusion and potential liability of its own. Consider whether your business insurance policy has any language tied to firearms policy on the premises. Since some commercial policies were written assuming a default prohibited environment in states like the four we just named, and a policy default flip could theoretically intersect with how your coverage is worded, something worth a direct conversation with your insurance agent rather than an assumption either way. Option 3, and this is the option most businesses actually land on without realizing it is a distinct choice, you decide on a middle ground policy, permitting licensed, concealed carry specifically while prohibiting open carry, or restricting firearms only in specific areas of your property, like a bar or lounge area where alcohol is served, while allowing it elsewhere. This kind of nuanced policy is legally available to you. Property owners retain broad discretion to set specific, reasonable conditions rather than being limited to a simple binary allowed or banned choice. But it requires clearer signage and clearer staff training than either of the simpler options, since a nuanced policy that is not communicated clearly creates more confusion, not less. And confusion is exactly what generates the kind of confrontation you are trying to avoid by having a policy in the first place. Let's talk about liability, because this is the question I get asked most directly by business owners trying to understand this ruling. And the honest answer requires some nuance. Generally, a property owner who has not created a policy actively inviting armed customers and who is simply operating under the restored legal default is not automatically exposed to greater liability than before, since the default itself is a legal baseline set by the Supreme Court, not a business decision you made, and courts generally do not treat compliance with a controlling legal default as itself creating heightened liability exposure. Liability considerations shift more meaningfully if you actively choose a specific policy, particularly if you post a policy and then fail to enforce it consistently, since inconsistent enforcement of your own stated policy can itself become a liability issue independent of the underlying gun rights question, the same way inconsistently enforcing any other posted policy, a dress code, an age restriction, a no pets rule can create legal exposure regardless of what the specific policy happens to be about. This is exactly why picking one clear policy and training staff to apply it consistently matters more than which specific policy you pick, from a pure liability management perspective, and it is worth having a direct, specific conversation with your business's own insurance carrier, and if you have one, legal counsel, about how your particular policy choice interacts with your particular coverage, rather than assuming a general answer applies uniformly to every business type and every insurance policy. Here is a mistake I am already seeing business owners make in the weeks since this ruling, worth naming directly so you can avoid it. Some businesses assumed that because they operate in a state not on the list of 5 directly affected, Hawaii, California, Maryland, New York, and New Jersey, none of this applies to them at all. That is not quite right. Most states never had a default prohibition law like Hawaii's in the first place, meaning the traditional common law default, carriers presumptively welcome, unless the owner says otherwise, was already the rule in those states well before this ruling. If you operate in one of the other 45 states, this ruling likely does not change your actual legal environment at all. But it is worth confirming your own state was never part of this specific default rule category, rather than assuming based on general political reputation, since a state's overall gun politics do not always predict which specific legal mechanism, if any, it used for private property. Step back and think about the actual operational takeaway here, because it is simpler than the legal analysis makes it sound. Pick a policy, communicate it clearly through signage, staff training, or both. Enforce it consistently once you pick it. That is true, regardless of which of the 3 options you land on. And it was arguably true even before this ruling. The ruling simply removed the state law that used to make option 1 the automatic default, whether you had actually thought about it or not. The businesses that end up in a genuinely difficult position after this ruling are not the ones that pick a clear policy in either direction. They are the ones that never make an active decision at all, and end up applying whatever their newest employee happens to assume the rule is on any given day. A genuinely common outcome in businesses with high staff turnover or multiple part-time employees who were never given consistent training on a policy their manager assumed did not need to be actively stated at all. If this helped you actually figure out what to do with your own business rather than just understanding the legal theory, hit like so it reaches other business owners in Hawaii, California, Maryland, New York, or New Jersey who are working through this exact same decision right now, and subscribe if you have not, because I will be covering how each of those 4 remaining states' own laws get resolved in court over the coming months, which will matter directly for exactly this kind of practical business decision. This is not a one-time compliance task you finish and forget. As the litigation in California, Maryland, New York, and New Jersey resolves state by state, your own state's specific legal landscape could shift again, and staying current matters as much for your business as it does for any individual gun owner. Tell me in the comments which of the 3 options you are actually leaning toward for your own business, because that tells me exactly which signage language, staff training approach, or insurance question to go deeper on next.